Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. Ever since yesterday's hearing on the motion to continue, I've received several contacts from different people just asking, what's your opinion, Kathy, on how you feel Judge Hippler is leaning on ruling, having had the opportunity to watch oral argument before the court. It's difficult to say. At the end of the proceeding, Judge Hippler said words to the effect of, I'll take matters under advisement. I'll write the ruling that I feel is proper. But words to the effect of, you should plan on as if you are going to trial as scheduled, which is August 11th, 2025. But that then seems to suggest one of two things. Either Judge Hippler has not rendered a ruling as of yet. He might be leaning one way or the other, but wants to go back, dot some I's, cross some T's to make sure that that is his ruling. And then he gave the caveat of he reserves the right to rule in the manner that he deems appropriate. The defense's filing of the reply brief came very late. It was less than 48 hours before the hearing. It got filed on the 16th of June after the motion to continue had been pending for just about a month. It was filed on the 20th of May, so the court had sufficient time to look through that very long 40-page document. Also probably had sufficient time to look at the state's response and opposition, because that was filed on the 5th of June. But the reply, which then replies, it's the defense responding to the response and giving more legal authority and more reasons for the continuance. Court might not have had an opportunity to be fully apprised of all the case law, all the arguments, and he might change his mind if that's the case once he has a chance to read and reflect on all of the issues that Ms. Taylor raised going towards effective assistance of counsel, Mr. Koberger's due process privileges, all of the pretrial publicity that this case has had and how it might impact seating an impartial jury and a few other matters. But then I have to go back and think, Judge Hippler didn't ask a lot of questions. He usually asks questions if he needs specific information. He may research another case. He might ask one of the sides, okay, well, what about this case? How does that apply here? How does that change your reasoning, if any? He asked very few questions. The only time he asked a question and made a comment, really, was when Ms. Taylor was addressing the fact that this case has only been pending for approximately 2.5 years, and the average time for a DP case is 3.5 years. In other words, it's seeming as though the case was being rushed. What Judge Hippler, however, said, and this was from the reply, he certainly saw this, is that, well, isn't it true that that's in federal court, which moves at a snail's pace, 3.5 years, implying that in state court, it doesn't take that long. And Ms. Taylor couldn't respond as to what the average is in state court because that wasn't in her reply. She was only able to respond with, well, I don't practice in federal court, and then tried to continue to persuade the judge that Mr. Koberger's constitutional privileges mandate continuance, especially since this is a bifurcated trial where there's the trial, the case in chief, and then immediately following, it's the same jury, the penalty phase if there's a conviction. So we're going to wait. Judge Hippler did say that he would get an order out in short order, meaning he's not going to let the parties wait a very long time. He's usually very timely anyway with his orders, but in this case especially, since voir dire is coming up in just over a month on July 30th, the process of jury selection, I think it's incumbent that he does get it out so everybody does know exactly where they stand. When that order comes out, as well as the order on the closed hearing, which was on the motion regarding Mr. Koberger's offers of proof of alternate perpetrators, we will, of course, notify you. So please stay tuned. This is Kathy. Thank you for joining us today.